Welcome everybody to the 30th Florida Remediation Conference. My name is Gene Jones. I'm the Executive Director for a small nonprofit up in Tallahassee called the Southern Waste Information Exchange. 30-second elevator pitch. We basically assist industry and municipalities with waste issues, whether that be waste management, recycling, or remediation. So if you allow me, I'm going to make a couple of quick opening comments, and then I'm going to turn it over to Robyn and Neely to run this opening session. First off, I need to thank the sponsors for the conference. As is with any conference, if it weren't for the sponsors and the exhibitors, we wouldn't be able to make it happen. So thank you, sponsors. Allow me to make a couple of opening comments real quick. If everybody can silence their cell phones. Proceedings, everything that you see over the course of today and tomorrow, all the presentations we'll shoot to PDF and make those available to everybody post-event, as well as we are recording this via Zoom. Welcome virtual attendees. List of participants. If you don't want your contact information released, please let me know, because the VIP registrants, the exhibitors, and sponsors are going to get full contact information. I will send out a list of attendees, names and affiliations only to everybody else. Certificates of attendance, if you are a PE, PG, or need some form of continuing education credits, we do make that available. There is a $25 fee for that, for processing, and you can see us out at the reg desk. Bathrooms, if you haven't found them already, they are back almost where we were last night for near Signature 1. Receptions and breaks. Everything, all food and beverage is going to be held from this point forward in the exhibit hall. Social media pages, one of the key things about conferences like this is the networking. So I encourage you to join the Facebook. If you're not on Facebook, join the LinkedIn group page. And network, let people know why you're here, what you're here to learn, and who you want to meet. Scam notice, if you haven't been scammed already, I try to advise everybody, do not buy a list of attendees off the website or off of the internet by email. Constantly get those sent out. They kind of prey on exhibitors or try to get you to make a hotel reservation with them. I'm not going to call you to make a hotel reservation, nor will my staff call you to sell you a list. Our media sponsors, who organizes the conference. A couple of quick notices. Our next event for next year is going to be held October 25th through the 27th. We're changing it up a little bit in terms of our day format. Normally we do the golf tournament on the opening day. Have exhibitors come in. That's why we did our reception last night, because exhibitors were coming off the course, so we did our reception out at the pool. Next year we're going to start on a Sunday and run through a Tuesday with the golf tournament on a Tuesday after the conference is over. The other thing that we're doing is we're going to be doing a drone conference immediately following FRC next year. So if any of the consultants in the room are using drones for business, you may want to take advantage of this conference. We've got PFAS Forum coming up May 13th through the 15th, right back here at the Rosen Center. And then lastly, every year we run an event for charity, right? And so this year we are doing the Ronald McDonald House, which we raised funds yesterday from the golf tournament, and then as part of the conference we do a 50-50 raffle. We are going to, and the winner of the raffle tonight, normally we get about $2,000 off of the raffle. As we did last year, the winner gets the choice. They can either take the cash, or this year we've got a bottle of Pappy 20-year. Howard Nelson has told me that he's foregone conclusion that he is going to get that bottle, so we'll see.
I will be leaving with that.
Yeah, all right. So if you win, the value of this is about $2,500, right? So you can either take the cash or the bottle. And if you take the bottle, Howard's going to come up to you and try to buy it from you if he hasn't won it already. And then the proceeds will go to Ronald McDonald House. And then also we're doing the Drum of Cheer, just as we've done in years past. That will also take place immediately after we do the raffle. And I think that is it with my opening comments. It is. So I am going to turn it over to Robyn Neely, Robyn is partner, chair of environmental and natural resource practice for Akerman. So ma'am, it is all yours to run. I'm taking this before Howard steals it.
I'll hold it if you want.
Yeah.
All right, good morning, everybody. Hope everybody's doing well. I am going to introduce you to my esteemed colleagues, starting from left to right. Laurel Lockett is a partner with Carlton Fields, awesome environmental attorney. And next, also going from left to right, Howard Nelson, partner with Bilzin Sumberg. I'm not going to get your specific titles correct, but I think many people know Howard. Next to Howard is Michael Larson. He is a partner, one of my partners in our Akerman Tallahassee office, practices environmental and environmental litigation. And then esteemed Michael Goldstein next, the Brownfield godfather extraordinaire, former Akerman partner that I still claim him as part of the team. And then finally on the end, we've got Michael Stag with Stag Liuzza. I practiced that, but not well. But Liuzza, he is a environmental litigation specialist. If anybody attended the PFAS forum, he was on one of the panels for the PFAS forum. His firm is involved in the AFFF litigation, and he's going to give us some update, and I've got some questions for him to walk through. So we're excited to be here, and we'll dive in. I think our topics should be very informative, give you some insights on where we think the Florida Department of Environmental Protection is headed this year, hopefully to give us additional tools to clean sites up and complete remediation. So I think it should be very informative and helpful for you. So I'll start with my first question to Laurel. So everybody may remember, or many people may remember, under Chapter 62-524, the Florida Administrative Code, there were EDB zones that were designated by, it was probably DER at the time. And so Laurel, is there anything new happening on 62-524?
Funny you should ask. Yes. So, yeah, and I think this is really kind of instructive, because if you look at what we did back in the 80s with EDB, that was sort of a good starting point for how we might deal with PFAS today. At that point, the legislature, and that was in '88, required DEP to adopt 62-524 in order to identify areas that were contaminated and then prevent the installation of potable wells in those areas without appropriate well construction details. So obviously the intent was, protection of the public, and that's great. If you look at how that rule operated, you basically had areas that were identified, and in many cases they were as small as just a single well where there had been an EDB detection, and then there was a buffer area that was described around it. No requirements of any kind of 62-780 delineation. It was just sort of and the purpose obviously then was you had an identified area. Well driller would be notified if they they were, when they applied for a well permit, it would be flagged, and then they would know that there was contamination. That would be a perfect fit for PFAS. The problem was, however, the way the rule was constructed, it required the ERC to actually adopt those areas, and so nothing has been done since 1994, basically. There were over 400,000 acres that were affected by EDB, and in some cases chlorinated solvents that were initially delineated. Obviously the process of going through the ERC is just way too cumbersome to deal with something like PFAS. The other disadvantage of the rule, the way it was structured, was basically, it was like the equivalent of a hammer and chisel on a tablet, no use of technology, and obviously we have lots of advantages now. We could take take advantage of. So DEP and the FBA started looking at possibly updating 524 maybe a decade ago. And finally, we started talking to them in earnest in 2024. And as a result of those discussions, the FBA, filed a petition for rulemaking in June. And we basically proposed a complete revamp of the rule. One of the key elements was we suggested that private parties or governmental entities, municipalities, could propose, based on data that met QA, QC requirements, delineation of areas. And not in the 62,780 sense. If I knew I had impacts in a particular area, that should be sufficient to then put the well drillers and the public on notice. No ERC involvement, we don't think that's required. DEP would just simply do this the way they do now with the process for implementing, for example, non-recorded institutional controls. And then, most importantly, what would be in it for the FBA, in addition, would be that those delineated areas could serve for a non-recorded control for site closure. So that was the positive for us. We have been going back and forth trading drafts on this. It's definitely a work in progress. I think we have agreement on some critical issues. The first, and I think the most important, is that DEP can do this. They can delineate areas without involvement of the ERC. So theoretically, it could be a much more nimble process. We agree that a 62,780 delineation, in the context of a cleanup rule, that would be a sufficient basis for delineation, but the FBA does not think that should be the only way. I mean, we have to have the ability to respond to like an imminent threat. And if you have QA data that demonstrates contamination, you ought to be able to just bring that in and ask for a delineation, understanding that it can be modified. There are a lot of open policy issues that remain to be decided, and I think the most important of which probably is what kind of notice is required for this. Under the ERC, the only notice of delineation or proposed delineation was publication, not actual notice, like actually, looking up the addresses of all these people within a certain area and then sending actual notice. So that's a key point that remains to be decided. But since we filed the petition in June, I think they have until the first quarter, sometime in the first quarter, to actually move forward with the rule. So you will see something, I think, within, certainly by the middle of next year, and we're hoping this will be sort of a way to deal with the PFAS issue, other emerging contaminants, and also ultimately serve as a basis for closure of sites under 780 outside of like the water management district, where you have the ability to use the NRIC process.
Yeah, thanks, Laurel. So I have another question. You probably have a question,
Well, I've got
too.
a question on
On her. Yeah, no, exactly.
Sure.
All right, so my question real quick, Laurel, is, say you have a private well that's detected PFAS, to seek this delineation, is it your expectation that DEP will want you then to attempt to delineate the how widespread the PFAS is, and how will that work practically?
I think that is one of those issues that remains to be seen. I think the department agrees that if I were to come in with a complete 62,780 delineation, that would be sufficient. In the absence of that, we certainly don't think that should be required, and I think that remains to be seen, because if you take something like PFAS, and this was the same thing with EDB, who knows where the source is? It's ubiquitous, and there are going to be other emerging contaminants at those very low levels. The sources are not going to be able to be determined with any kind of certainty. So to require delineation in the 780 cents really doesn't make sense. I mean, we want the public to know, and we want the well drillers to know, hey, if you put a well here, you're going to have special construction details. So that's a point, I think, to be worked out.
Okay, go ahead, Howard.
So a couple of other issues to add to it. Are we looking at stuff that's not, also it's stuff that's not considered traditional contamination, even though it's spelled out, such as salinity plumes that would,
That's a good question.
they generally fail, TDS and those issues, but also a good indicator of a delineable area where we should not be sinking wells without further analysis. That's one. Two, is the rule still going to just apply to potable wells, or will it also be an overlay that puts some type of additional conditions or restrictions on, say, dewatering or irrigative uses?
No, I mean, the well itself, or the rule itself is just designed to work for potable wells, not municipal wells, but,
Right.
private potable wells. But I think, the fact that you will have a layer essentially in the Water Management District permitting file, so that if someone applies for a permit within that area, they will know that there is an issue.
But
And
you
then-
can have a hard time using it as an NREC if it doesn't restrict other access to groundwater.
I think it'll depend on the contaminant.
Okay.
And specifically how it's addressed, obviously. I mean, you have situations now where you have issues with a potable use, but not necessarily an irrigation use. And I think it'll be a case-by-case evaluation.
And then the last question, sorry, and then I'll shut up. Have you had conversations with DEP about some other good indicators, not just the 62780 delineation, but Palm Beach County, lovely county, largest agricultural production county east of the Mississippi, has areas that have had continuous agricultural use for 80 or more years, 100 years in some cases, over and over, and there is spot information in there regarding contaminant load, but it's certainly not a 62780 worthy delineation, but things like that, or the historical boundaries of the larger Hillsborough County cattle ranches, things like that.
Yeah, I think that's exactly the situation with EDB, which was a soil fumigant. If you have data today that's collected in accordance with the department's QA/QC requirements, and you are concerned, there should be no reason that could not be a point in the database with a described buffer, and that's the way the rule was designed initially. But because of the problems with trying to get something through the ERC, it just hasn't been used.
And one more question that just popped into my head. What about existing wells within that overlay area?
That's a tough
Look at
question.
him, look at me.
Thank you,
That was just
Michael.
a
That is a
handoff.
super tough question because I think that DEP is very concerned about taking away property rights, right? So, but it's a protectiveness question, right? They need to be notified if there is
an NREC
contamination.
issue.
Yeah, it's a similar issue to NREC.
Yeah.
I mean, I think we have to be careful not to conflate two issues. Notice, this rule is about notice.
Right.
Notice-
Protectiveness. Yeah.
Yeah, protectiveness, notice to well drillers, notice to the public in an effective means. That is not a taking of a property right. I mean, that's fulfilling a statutory obligation that the
Right.
department has, so.
The whole protection of human health and
Correct,
safety,
yeah.
one of the primary responsibilities of DEP. We've got to keep moving because everybody else has got to, go ahead. We'll come back to you, Howard. Okay. All right, Michael Stag. So can you give us an update on, sticking with the PFAS theme, Can you give us an update on the AFFF litigation and what is being litigated and status?
Yeah, if we can, I think we pulled up my first slide. For those of you who are not familiar with AFFF, it's aqueous film forming foam, which is the firefighting foam. It's the biggest environmental litigation I've ever seen. I was involved with the BP oil spill and thought that was going to be the biggest one I would ever see in my lifetime, and then this one came along. And the reason it's so big is because of the breadth of how you end up in this case. It's a multi-district litigation. Multi-district litigation is a way for courts to consolidate cases, not a class action. That's a different procedural device to consolidate cases. So what happens is, if you file a case in Alaska, Florida, New Orleans, where I'm from, and it relates to PFAS damages that in part relate in any way to firefighting foam, you're going to end up in this litigation. And of course, firefighting foam isn't the only source of these PFAS chemicals that are in the environment, but it is probably the one that has caused the most widespread contamination because of where it was used, how it was used, how long it's been used, et cetera, et cetera. So what ends up in this case, and you got to think about this case like it's really a cost recovery litigation. You've got drinking water systems. You have some states that were early on enforcing clean drinking water standards at the state level. Now the EPA has clean drinking water standards that they promulgated. And so there's costs associated with responding to those unfunded mandates. And so drinking water systems are first, and the reason I'm going to talk more about that because that's the first piece of it that has been settled in part. It's only partially settled. Everything else is not settled. Wastewater systems also will have costs. That's something that regulators are taking a good look at. Some states are very aggressive, probably the same ones that had state regulations on drinking water, like New York. I represent the city of Buffalo on their wastewater system, and they're having to build out a whole new filtration system because their effluent and their discharges under their permit are going to have PFAS, and they're going to need to take it out. So that's a big, big cost. Airports, they were mandated by the FAA to use AFFF. They used it for a long time. Most of them trained on site, and so airports need cleanups. The PFAS gets on the surface of airports, and then it migrates into shallow groundwater and off-site and surface water, et cetera. And this stuff, because it's a forever chemical, it's going to be there a long time. It's not going anywhere. Well, it's going places, but it's not biodegrading. And then, of course, fire training centers. Those are real hot spots. Represent several of those as well. And then we have large landowners. There's examples include a cattle rancher out in New Mexico who, it was a dairy farm near a military site, and they had to put down their entire herd and shut down their operations because there were PFAS in the dairy milk and the cheese that they were selling. And that's part of this case as well. I also have ranchers in Montana and North Dakota as well that we represent. And then, of course, there's personal injury. That mainly has to do with folks who were exposed by using the foam, but also some water drinkers in severely contaminated water systems, like Colorado Springs and Pennsylvania near large military facilities. So this case has a lot of different claims in it, and it's still, in my view, at the beginning. There's also some states that have not settled are also in this case as well. They call them the sovereign defendants, or the sovereign plaintiffs. So there's a lot of different types of claims that are in this case, and only a small part of it has been settled at this point.
So do you expect that there will be, you said there's only a small part of this that's been settled. It's been settled so far. Do you expect a lot more litigation surrounding this issue?
I do. I mean, the judge, the way these work is typically the courts, one of the tools in the MDL judge's toolbox is to set bellwether trials. And that's how the judge was able to get drinking water partially settled with 3M and DuPont. He set a bellwether trial. It was Stuart, Florida, that was set for trial first. It was June of 23. It was supposed to go to trial. Never made it to trial. What ended up happening was 3M and DuPont agreed on the eve of trial to do a settlement, and they didn't just settle Stuart, Florida. They settled nationally. And the way they did it didn't start as a class, but it finished in a class settlement, and it was an opt-out class. So what that means is if you were a public drinking water system that was listed on an exhibit to the settlement agreement, it's a master settlement agreement that has the terms of the settlement, and there's lists as exhibits attached to it, and it names all the water systems that were qualifying claimants and were settling claimants. And there was an opt-out deadline back in 23 after the judge approved the settlement. And if you did not opt out by that deadline, then you were in the settlement by default. So even if you did nothing, if you didn't file a suit, if you didn't do anything and you were on that list, then you settled your case. And what that means is you've released 3M and DuPont for any and all PFAS liability now and forever under the terms of the settlement, in exchange for going to get money out of these funds, out of this fund they created. DuPont put up about $1 billion, a little over $1 billion, and 3M put up between $10.5 to $12.5 billion. And this is just public drinking water. And then there's also a partial settlement with Tyco and BASF. Its totals about $1 billion. They settled that in a different way. It's a different structure. Not all water systems were included. The water systems that were excluded, I'm advising them that they need to file a claim in the MDL. At some point, I think the judge is working on personal injury now. If he wants to get that out of the way, he's doing some things related to the property claims, which includes airports, fire training, that type of thing. I think these other claims will get resolved at some point, but it's taking a lot longer than I would like, but it is a big case and it's complicated.
Yeah, go ahead, Michael.
Robyn, I have a question for Michael. You mentioned dairy farms in passing, and I know a lot of your work and a lot of work at the multi-district level involves wastewater claims and groundwater. Gene has been consistently putting on wonderful redevelopment-focused conferences, and we spend a lot of time in these conferences, at least recently, talking about biosolids, PFAS and biosolids. What do you see in the near future, or even the long-term future, regarding PFAS litigation as it relates to biosolids? Because I know that has relevance and resonance to a lot of environmental practitioners in Florida who are involved in environmental redevelopment.
Yeah, I mean, we're making claims related to sewage treatment, so biosolids are part of this as well. I think it's, you got to think of this like you're standing in a long, long line. There are hundreds of thousands, well, at least over 100,000 lawsuits filed and consolidated in this case at this point. So there's a lot of cases that the judge is dealing with, and these MDL judges, they really try to resolve as much as they can for judicial economy reasons. If we had to try each one of these cases, we'd have to get more judges and more courts, I think. So it's very important to see if we can come up with broad solutions to as much of this litigation as we can, like we did with the drinking water. It's been done in the drinking water, so I think we see a template that could be applied to some of these other, utilities. Without getting too much into the details of the settlement, one of the primary funds is based on drinking water, size of your water system measured in your flow rates, and then also your PFAS score as measured in your water sources, not your finished water, the water sources, not just the intake. We're talking about each water source. It's like each water source is a pot of money potentially. So if you have 20 or 30 groundwater wells, you have to test each one of those groundwater wells. And you could have zeros in a lot of your groundwater wells, but if you have PFAS in some of those, then you're going to get paid for those water sources that have PFAS because you're having to deal with that in your system. That's essentially how it works. There are other funds as well, and it's a little more complicated than that, but in a nutshell, that's how they're doing it. And I could see that applied to wastewater and sewage treatment in other ways.
Thank you. And then one last question, then we'll keep moving on because we have lots of good topics to cover. Do you think they're going to have enough money to pay out on all these settlements?
I mean, that remains to be seen. I mean, 3M has remained solvent so far. I mean, I did an informal stress test, and I think they would need to incur $60 billion in liability at one time. They have been able to structure this over time. For example, the 3M settlement of the water, it pays over 10 years. And so they've been able to structure these payments. And then they just settled with New Jersey. Well, it's not final, but they have a settlement with New Jersey that's around less than $500 million. So they're trying to structure this out. I think they know that they have a long-term contingent liability, and they need to do what they can to try to get it under control. And it appears to me, I'm not in the boardroom with 3M, but based on what I'm seeing, my sense is that they want to resolve as much of this as they can, because it's going to be around for a while, and these litigation issues will be around for a while as well. So I think they'll have enough money at the end of the day. Well, but
That's fair.
We'll see.
Yeah, we'll
Yeah.
see. We'll see. All right. Thank you, Michael Stag.
You're
So
welcome.
moving on to another kind of tool in our toolbox. With the Florida Brownfield program, our clients are very focused, or many of my clients are very focused on voluntary cleanup tax credits, in addition to the liability protection under the statute. So, Michael Larson, I understand that DEP is in the middle of a rulemaking effort to clarify voluntary cleanup tax credits. Can you give us an update on that?
Yes, Robyn, absolutely. Thank you for your question. As you mentioned, the Florida Department of Environmental Protection is in the process of rulemaking with respect to Chapter 62788 of the Florida Administrative Code, and that is the rule that pertains to voluntary cleanup tax credits. And most of you probably know what a voluntary cleanup tax credit is, but just in case, it's a tax credit that's available for brownfield sites where the site is entered into a brownfield site rehabilitation agreement, or certain types of dry cleaner sites that have entered into a voluntary cleanup agreement. So as you can see on the slide here, this is the rulemaking timeline. The notice of development of rulemaking was published earlier this year in July, and there was a notice of workshop hearing published in September. Workshop actually was held in person at DEP on October 7th, and the Florida Brownfields Association, which I am a board member of and the president-elect of, and many of us on the stage are engaged with the Florida Brownfields Association. Some of us may have started the Florida Brownfields Association back in the day. The FBA is very interested in this rule. They submitted a letter. We gathered comments from different members, board members, other members, stakeholders, and submitted a letter on October 27th in response to the draft rule. And FBA is also going to be having a meeting with DEP coming up this week, November 6th. And so the FBA will be present and discuss some of the comments that we submitted. And if you are interested in reviewing the rule, the draft rule is on DEP's website. The comment period is still open. Comment period is open until November 14th if you are inclined to submit any comments.
Thank you. Can you tell us what the key changes are that's in the proposed rule?
Absolutely. So on the next slide, we have some key changes that are being proposed in the amended rule. These are just some of the highlights. If you want to pull the rule and review in detail, please feel free to do so. But these are some of the high points that jumped out to me. The first is that the amended rule would require inclusion of a cost summary table in the voluntary cleanup tax credit application. A summary table is something that we often include anyway because these applications can be hundreds or thousands of pages long, including many invoices, payment records, contract documents. So it just helps DEP review and organize the information, but that requirement would actually be codified in the rule, so it would have to include a table with the payee's name, invoice number, statement date, payment amount, and the claim costs that are integral to site rehabilitation. So that's a proposed change in the rule. Another big change would be that the amended rule would define redevelopment and exclude tax credits that relate to redevelopment. So that word redevelopment is not currently defined in the rule. It's something that we sometimes submit a tax credit application to DEP and will receive questions back informally, asking or trying to tease out what is site rehabilitation, which is tax credit eligible, versus redevelopment, which the agency often views as not tax credit eligible. And we get those questions and we go back and forth and attempt to discern what is redevelopment versus site rehabilitation. But now that concept would potentially be codified in the rule so that redevelopment would be defined essentially to mean construction activities at the site that are not necessary to implement the requirements of Chapter 62-780. So that's a big change. This rule is not yet final, and the FBA did have some concerns regarding the inclusion of that definition and that categorical exclusion that we're still working with DEP on, but that's something to definitely take note of. The rule would also, if it were to be amended in its current form, would exclude costs spent to address contamination that did not result from polluting activity at the site or is not emanating from the site. That's slightly different language than is currently in the rule. The current rule is drafted so that the costs are excluded to address contamination that is from a source outside of the site. This rule, if it were to be amended, includes this language of polluting activity at the site. So what does that mean? The FBA had some concerns as to that term. That term is not defined in the proposed rule. We raised some of those concerns in the letter that was submitted, and we'll probably talk through that in a little more detail this Thursday at our meeting. And then the last bucket of changes really deals with engineering controls. So there are several proposed changes to the rule that seek to prorate out costs or exclude costs relating to certain types of engineering controls. For example, if a slab or foundation is in excess of what DEP deems is required to be an engineering control, then those costs associated with the excess thickness would be prorated out. And the current rule has some similar language, but again, this reiterates that thickness of an engineering control is something to be examined. So in my experience, we go back and forth with DEP a lot on this. If you get an engineering control that's greater than 4 to 6 inches, they might start scrutinizing it and trying to prorate out costs associated with that additional thickness. They might also try to prorate out costs relating to stem walls, rebar, excess sub-base materials that are included underneath the slab. So usually there's some back and forth, but this rule really seeks to tighten the screws a little bit and really clarify what is eligible in the view of DEP and what is not. Another big change related to engineering controls is that engineering control surfaces that are installed beyond the known original horizontal extent of the soil contamination would be excluded. So this is important if you have a soil plume that's delineated, but then you're potentially moving contaminated soils around on the site, and the original area of contamination expands and is greater than as was originally identified in the site assessment. Those costs could be prorated out under this rule. Another big change is that the replacement of surfaces serving as engineering controls would not be VICTIC eligible. And this is something that I've encountered from time to time where DEP has said, you remove 2 feet of clean fill serving as a cap to maybe install utility lines, and you put the cap back. That cost is not VICTIC eligible. Well, this rule would codify that exclusion. It would also, and kind of a corollary to that, prior surfaces. So the prior surfaces that exist at a site would be considered to act as engineering controls. So a prior pervious or impervious surface under this rule, regardless of how long it's existed at the site, would be presumed to have acted as an engineering control unless the applicant can demonstrate otherwise through maybe historical photos showing that the surface was actually disturbed or did not actually serve as an engineering control. So the onus is on the applicant to show that the prior surface did not serve as an engineering control, and that replacement of that surface or installation of a new service in its place should actually be VICTIC eligible. So the burden would be on the applicant to show that under the rule. And kind of the last item that I have on the slides, and there are some more changes in the rule, these are just kind of the key changes in my mind, is that surfaces that are installed in areas where soil contamination was not found during the site assessment under 62780 would not be eligible. So make sure that your delineation is clear in the site assessment, and you know where, and that you identify what needs to be identified, because if something's not identified in the site assessment, then you're not going to be able to get tax credits in connection with the engineering controls. And I guess I'll just mention one more thing, kind of the last item, but it relates to that. It's not on the slides, but make sure that if you're relying on technical documents in support of your application, make sure that they are submitted to DEP and they're in the site file at the time your VICTIC application is submitted. DEP under this current or the amended rule is not going to look beyond what's already in the site file. They may request additional information, but the new rule would clarify that those requests for additional information will not cure a defect in your application. So make sure all your important technical documents are in the site file at the time you submit your application.
Yeah, very, very interesting, Michael. So, simplistic question. So on these ag and golf course redevelopment sites, a lot of time there will be arsenic contamination throughout a site, and you're going to redevelop, and you're going to take your quite a bit of your impacted soil, and you're going to manage it under a road, impervious surface, as an engineering control. Under this new rule, is that going to be still allowed, or how is that going to work?
Well,
I mean, what is your crystal ball interpretation? How about that's the question?
So the rule is not yet final, and we are still going back and forth with DEP in terms of FBA's comments and whether maybe that might have some impact here. But essentially, if you create a larger contaminated area beyond what was originally identified in the site assessment, then the cost associated with capping that larger portion of the contaminated area may not be VICTIC eligible unless you can come up with some sort of creative argument as to why. So this seeks to make some really significant changes.
Significant changes. So be aware of that. I would argue that you're not, it's already in a contaminated area, and you're not making it a larger area, but you're properly managing it in a different location.
And just to remind us all,
yes.
Under 62780, you cannot enlarge by your management. You cannot enlarge the surface of your contaminated site anyways.
Right.
So unless as part of your site assessment, you've been able to provide evidence that shows that your site is ubiquitously contaminated.
Correct.
You wouldn't be able to move, you wouldn't be able to manage by moving out to an uncontaminated
Right.
portion
They don't want
anyways.
you to put soil in an uncontaminated area, but I don't know how they're going to interpret that. Go ahead, Laurel.
Yeah, but you remember you have, if it's a RCRA site, right, and it's a RCRA BISRA, then you can have an area of contamination, so you actually can relocate.
Okay.
Not in the typical 780
Yeah, but
sense,
not in the
RCRA
typical
And
780.
under the informal Jorge Caspary rule, you can define your own contaminated site, but you may need to be intelligent about how you do your assessment as part of that.
Correct, and
to
how you
eligibilize
write your
yourself
site
for
assessment
VICTIC credit.
report and identify the ubiquitous nature. Go ahead, Michael.
To pick up on what Laurel said, there is a RCRA brownfield site rehabilitation agreement model. And so you can, under the auspices of 62780, create this larger site if you have a RCRA BISRA and an approved soil management plan. And I would argue that it may even be possible outside of RCRA to relocate contaminated soil in a way that technically disperses contaminant levels from lower areas of contamination to higher areas of contamination and vice versa, still be eligible for the tax credit, provided that it's in an approved soil management plan. I want to say one other thing about Michael's presentation. Michael was very charitable in that he characterized all of the proposed changes in the VICTIC rule as highlights. I'm not going to be so charitable. We love our good friends at the DEP. This is not personal. They work hard. They're committed to the cause. We have a long history of cooperation and collaboration. But there are many fundamental aspects of this rule that are just dead wrong. And I would characterize them as lowlights, not highlights. And there are plenty of folks in the industry who are watching this closely that are highly motivated for good reasons to challenge some of these more controversial and unnecessary aspects of the rule that create practice risk and malpractice risk for all of the practitioners sitting here in the room if they're not properly understood. The conventional wisdom is that VICTICs or voluntary cleanup tax credits are available for engineering controls, period. This rule looks to redefine what an engineering control is in many ways that are counterintuitive and run contrary to the spirit of redevelopment. This is, at its essence, an economic rule, an economic program that has an environmental flavor to it, not the opposite way around. This is a rule that was conceived in the crucible of convincing parties sitting on the sideline innocently with a lot of capital to move towards contaminated sites that they didn't need to mess with at all. And so the legislature said, we're going to create a very warm and embracing program for you with all of these economic incentives. And to, for example, come up with a rule that puts the burden on an applicant to look at an aerial photo from a building that may have existed, a packing plant on an agricultural site in 1960, and say that that building did not serve as an appropriate barrier to prevent direct exposure when there's nothing other than a single picture at a point in time. That creates venture risk and economic risk and legal risk and on and on and on. It's really
And it's just plain wrong.
Right.
Right.
So we love our friends at the DEP. There are good aspects of the rule. There are highlights, in fact, but there are also lowlights. If it passes as promulgated, everyone who's involved in environmental redevelopment and counseling clients, public sector and private sector on the rule needs to become familiar with the rule. But just be assured that there are folks out there who feel strongly that some of this needs to be seriously amended before the rule becomes finalized.
And I've got one quick question. As we move through the new rule, and some of this is what DEP has been enforcing without a rule for a while, the thickness of the slab. We've seen that on VICTIC credits
Right.
for a while. Are you sensing any appetite when you go in at the end of the day now for your bonus credit for a look back on what they've already given you VICTIC credits on and de-eligibilizing that from the bonus credits?
I would think that if tax credits had already been approved in an eligibility letter, then the department is bound by that prior approval in terms of calculating what's eligible for the tax credit bonus. But it's hard to say. I think there's a strong argument that they should be bound by what's already been approved under the prior rule. And I don't think the current rule amendment or proposed amendment really addresses that one way or another. But that's a great point. That's a good question. I would hope they would not go back and reassess.
I would hope if a federal judge ordered the release of money for SNAP benefits that somebody would do it, but apparently not. So.
And now that you mention legal issues, so this rule is not yet final. There is a chance that even if it is promulgated in its current form or some slightly modified form, that there could be a rule challenge as, asserting that the agency has exceeded its delegated authority for rulemaking. So the statute that allows the promulgation of this rulemaking really speaks to allowing the department to issue necessary forms relating to the application and to issue rules that contain guidelines and procedures to administer the VICTIC statute. So I think there are some arguments to be made that this proposed rule goes well beyond what is allowed under the statute.
And to DEP's credit, they're listening. They're listening, they hear our concerns, and it's why we have this meeting scheduled for later in the week with the FBA, with the Florida Brownfields Association. Michael Larson did a great job in putting together a comment letter. Michael, maybe you can make that available to Gene. He can post it to the website so the entire conference here can read it and appreciate the good work that you've done and the way in which DEP is continuing to collaborate with stakeholders.
Yeah, happy to do that.
Yeah, and thank you. I think that this is an important rule that everybody should be watching carefully, and hopefully, as Michael Larson and Howard Nelson and Michael Goldstein indicate, there's still an opportunity to shape the rule with the comments and input and work through some additional language changes before it's promulgated. So, Howard. So another tool in our toolbox, and if you're old like me, you may remember the Contaminated Media Forum. So Howard, do you think you can explain why it's important that what is old is new again, and
Well,
we should
let
revisit the Contaminated Media Forum?
Let me step back half a step. By just a show of hands, how many people sitting in the audience today are familiar with the Contaminated Media Forum? Yeah, see, not a majority of the room. So let me tell you a story that happened maybe long ago in a not so mythical land, not so far away. But there used to be a creature called the Contaminated Media Forum. And this creature allowed the regulating groups, DEP largely, some of the delegated programs, to sit in a room with the regulated community and discuss issues of common interest. The discussions over the years were amendment of the CTLs in 62777, amendment of procedures for RMO 1, 2, and 3 site cleanups in 62780, the process for institutional controls, and we stopped meeting about 4 years ago, I think. And this was a meeting that didn't happen quarterly, it didn't happen annually, it happened periodically when there was a groundswell of, hey, there's some stuff we need to talk about. And it happened in different cities, mostly Tallahassee, but not always Tallahassee. But it was a great meeting place for just a discussion. Lots of our discussions never saw the fruit ripen and get harvested, but it was a great discussion amongst the regulated community and the regulators. But there's another reason to have it and to want it back. For those of you who are familiar with wetlands mitigation, years ago we adopted as a state not only a uniform delineation model for the landward extent of wetlands and surface waters, but also a uniform statewide mitigation assessment methodology. And by statute, it said that every agency in the state, FDEP, the water management districts, local wetlands permitting programs, had to use these two guidelines, a uniform delineation model and a uniform mitigation assessment model. Similar to what we have today. If you're looking at contaminated sites, you look at 62777 to determine what contamination is, and you look at 62780 to determine how to clean up and when you've reached your cleanup goals. But what we find, similar to what the wetlands folk found, is that notwithstanding a similar or an identical rule applicable throughout the state, within a year or two of passage, every different agency interpreted the rule differently, and you had a water management district here interpreting the same rule as a DEP district office here completely differently. And they got together on what became known as a series of anti-drift meetings. And that's a pretty self-explanatory concept. We've got one common rule. We need to make sure in our application as we're talking to ourselves that we don't drift away from a common understanding of what the rule is. And for those of you who are assessors or remedial practitioners in the room or attorneys involved in remedial practice, you will know going around the state that trying to remediate a site under Chapter 24 and the delegated authority issued to Miami-Dade County is a lot different than trying to remediate a site in the Northeast District Office of DEP or with the Tallahassee Business Assistance folks or with Chapter 24 of Broward County or with, and I'm sorry I don't have the Hillsborough County rule number buried in my head, but in Hillsborough County. They're different, but they're all supposed to be based with some minor modifications through the delegation on 62777 and 62780. And the Contaminated Media Forum would be a perfect place to have those anti-drift meetings. There's also some discussion, and there's been discussion down in Miami-Dade County of having regional Contaminated Media Forum that gets together Dade, Broward, and the DEP Southeast District Office and make sure that they have a commonality of understanding of what the rules go. But that's the CMF in a nutshell, and
Do you
We'll
think
open it up
that
to other
DEP
questions.
has an appetite to reconstitute? I mean, perhaps it's not necessary
there
for
has
them
been
to,
an appetite in the regulated community,
in the regulated
in the
community.
regulated community since the day after the last meeting we held.
How about the regulatory community?
It doesn't seem as much of an appetite.
Not as much urgency. I
Right.
mean, we have the district support program, which is intended to make it more uniform, but Michael Goldstein, you had a comment.
Yeah.
Just real quick, in preparing for this panel, we talked about the Contaminated Media Forum, and I applaud Howard for bringing it forward as a potential priority among the regulated community and with the regulators. I think there's a little bit of a difference in how to make that happen. I think that it's so important, we'll call it the Howard Nelson Contaminated Media Forum, that this should be a creature of statute. And the comparison that I made was to, in 1997, when the Brownfields Redevelopment Act was passed, there was a component that called for and mandated the creation of an Environmental Equity and Justice Commission. So that took all of the administrative discretion out of convening the meeting, scheduling the meeting, staffing the meeting, providing it with resources. Now, we can have a whole conversation about why environmental justice never was able to take root in the state of Florida. That's a different conference. But with respect to the Contaminated Media Forum, I think that this should be a creature of statute, that it should be impaneled with regulatory agencies, with the Department of Environmental Protection, with the Department of Health, with the South Florida Water Management District, because there's a lot of cross-coordination with the water management districts and DEP and stakeholders in environmental redevelopment on stormwater and irrigation and NREX and the like. The FBA should have a seat at the table. Other affiliated constituencies should have a seat at the table. Certain practitioners should have a seat at the table. There should be appointees from the governor's office, from the delegated pollution control agencies, the local agencies and the like. I think that's the best way to give heft and meaning, and we'll use an NREC term, an IC term, durability to the work of the Contaminated Media Forum so that we don't have drift.
Right. And we discussed this in preparing for this panel, and Michael, I would tell you the only the only thing I would differ from you on that, one of the best things about the Contaminated Media Forum is everybody had a seat at the table if you wanted a seat at the table. It wasn't a delegate of this or a delegate of this or a delegate of this. And we would, I remember the meetings back before we started having them by phone more than anything else. And you'd have a hard time finding a room big enough to hold all the people who wanted to be in there for the discussion, not to mention the 100 other people who were attending by phone. So I'd be reluctant to set it up as a entity that has delegated people as opposed to just an entity of either statute or rule that must be conducted on some periodic basis and leave the membership to whoever wants to attend.
So some gentle pushback. I'm sorry, Laurel, real quick before I lose Howard's thought. Gentle pushback, Howard. If you can make the argument that if everyone has a voice, no one has a voice. And if this commission is impaneled by statute and given resources by statute in the way that I'm thinking about it, then the forum would travel across the state and have public hearings where anyone who wanted to go on record would have the opportunity to make public comment. That would be part of the record, but the forum, impaneled by statute, would actually vote and come to final action on whatever the issue du jour is. So we don't have guidance documents in draft form that sit around for years and linger, which is what we have. We were just talking about this, the stormwater guidance on contaminated sites, right? Let's call the question. The best way to do that, in my humble opinion, and I'll close here, is to have the forum statutorily impaneled.
And I have to say, I agree with Howard. One of the best things about the Contaminated Media Forum was that it convened when it was needed, and if you cared, you showed up, and we could accomplish so much in an 8-hour meeting. I mean, everyone would present their ideas. There'd typically be somebody who would be delegated to start with like a slideshow to sort of set up the issues. And then, you know, if DERM disagreed or DEP had a different thought or, you know, some trade, they would pop up and instantaneously that concern would be discussed by the whole group. And what you got in you know, 6 or 8 hours was an incredible consensus on issues. It was amazing. And so, and that is what led to the revision to the rule in 2014. Was the CMF was reconstituted, and we
do agree with Michael that it will be named after me, though, right?
yeah, it'll be named after Howard, right? Unless
Your legacy, Howard.
Yeah. Or maybe everyone who has gray hair will do some sort of combined thing. But that's kind of all of us, yeah. But I think if we could just get in the room with DEP and start talking again about some of these issues, because what's happening now is you get these draft guidance memos that come out of DEP, and they've had absolutely no input from industry, and they make absolutely no sense. And I'm seeing a lot of heads. It's like, where did this come from? It doesn't make any sense in the real world.
But it's not just DEP. We need DOH in the room. We need the Water Management District in the room, and they're not going to. We love these folks, but they're not going to come unless they're told to come.
Well, we just need to start it, and then hopefully, if it needs some sort of formality, we'll just see where it goes.
And Howard, so how do we get it restarted?
I'm sorry?
How do we get it restarted? I mean, I know Michael Goldstein said legislative.
I find generally that DEP is very, very, very responsive to questions that arise from recognized environmental agencies. The FBA is a great start, but I find that they're even more incentivized to do something when members of the House or Senate say, why aren't you doing this? And I think it's a job for our elected representatives to say, Why aren't you meeting and making this process more viable, more energetic? The CMF didn't come about solely to reduce regulations and make it easier. It came about to streamline thought and get some similarity of thought between the regulated and the regulatory and regulated communities, so that the process worked easier. Similar with the water management district, so that, or the water management districts and DEP on wetlands, so that you had a complementary, for lack of a better term, product review coming out of everyone using this rule, and everybody understood the common terminology. We all work in practice settings where there are other people in our group, and one of the things that I'm positive we all strive for is a similar product coming out the door. For the engineering consultants, the environmental engineering consultants, you guys strive for a consistent product going out the door. We strive for a consistent product no matter who does the work going out the door. We should, as part of the anti-drift effort, strive and expect a consistent product no matter where you're asking the question.
Thank you. All right, to bring us home, Michael Goldstein. So many people are probably familiar with the recent amendments to the Florida Brownfields statute, and Michael Goldstein did an excellent pre-conference panel yesterday afternoon and talked at length about this new legislation. So Michael, can you explain how you think the legislation is creating new opportunities for brownfield redevelopment in ways that weren't available previously?
Absolutely, I'll do that. I'll do the follow-up question. I want to give as much time back to the group as I can so we can get to questions and answers. I'm just going to talk very briefly. We had a great workshop yesterday. Howard, thank you for participating. Carrie, thank you for participating. I don't know if Carrie Barsh is still here.
And Laurel and I were in the audience to participate too.
And Jennifer with FDEP. All of those perspectives were appreciated. The legislation that passed this year, House Bill 733, which became effective on July 1, 2025, had tremendous legislative support. It went through 6 committees, 3 on the House side, 3 on the Senate side. They were referred out or passed unanimously. No concerns, no questions at any of the 6 stops. When it reached the House, the full chamber, it passed unanimously. When it reached the Senate chamber, it passed unanimously. It was signed by the governor. No sweat. It's a reflection of all the good, hard work that everyone in this room has been doing in support of environmental redevelopment. No scandals, no drama. The legislature loves the program. The governor loves the program. And as a result, we were able to, in very many substantive respects, rethink and recreate the Brownfields program. The most fundamental change, the most important change for practitioners in this room, from my perspective, is this. We now have the ability to portion smaller parcels of larger contaminated areas. Think landfills, think golf courses, think citrus groves and other ag sites, and get to closure on a portion parcel basis before the rest of the responsible parties, to the extent they even exist or are knowable, catch up to us. Historically, until July 1, 2025, you would have to do all of this work, whether you were in a BISRA or not, and wait for everyone else associated with that larger site to go through 62-780 before you were allowed to land the plane, before you were allowed to enter into a DRC, before you were allowed to pursue a non-recorded institutional control, which creates lots of transactional and financing and legal havoc. We talked about that at great length yesterday. I'm not going to go into that again in the interest of time, but just know that there is a meaningful early off-ramp to closure that allows practitioners to help clients and constituents frame and rethink how the cleanup and redevelopment process will occur before you get into a site. The rule has applicability, though, not only at the beginning of a project, but for parties who are midstream. There's some course correction that can be implemented in terms of how quickly you get to closure and not having to wait or rely on other parties. By getting to closure early and having the state recognize your own site, even though it's just a portion, you have access to greater access to voluntary cleanup tax credits because now you're not sharing with third parties. And then what we heard from Carrie Barsha yesterday was that she has clients who terminated eligibility, brownfield program eligibility early because they didn't want to wait for other parties to catch up. They're now going back into the program to enter into a BSRA to take advantage of tax credits that they left on the table. For practitioners, there is a wonderful new business opportunity in the rule, and that is to help clients navigate a very narrow path to daylight in demonstrating issues related to plume dispersion and contaminant dispersion. Without going into a lot of detail and spending a lot of time, the new rule is not a get out of jail free card for portion sites. From a technical perspective, one needs to demonstrate that your portion site isn't the source of a release that has migrated off-site, or that if it has migrated off-site, that you've resolved that off-site issue in the context of 62-780. So that's, to me, the most important aspect of the rule. The ways in which the rule creates other new opportunities for practitioners and for clients, both on the private sector side and the public sector side, is this. Federal program sites, which, although in theory could have participated in the Brownfields program, but in reality never would be able to participate in the Brownfields program because doing so would require EPA to forego their enforcement authority, which is never going to happen. That rule has been turned on its head, and the requirement now is simply to get a letter of no objection from EPA, which is already properly motivated to help facilitate redevelopment. There are 92 NPL sites in Florida that could be ready for reuse and could go through the Brownfields program with this new rule. So that's a wonderful opportunity. By the way, there are 63 NPL sites that have already gone through some form of redevelopment, not any of which took advantage of the economic incentives or the liability incentives, which they now can do. The final area of opportunity is for local governments. How many folks here are a local government or represent local governments? Show of hands? Well, you're bashful. I know that there are lots of folks here who represent local governments. We rolled forward the eligibility cutoff date for local governments. Under the old rule, if a local government caused or contributed to contamination on or after July 1, 1997, they would not be able to participate in the Brownfields program, take advantage of the tax credits or the liability protection. Now, under the new rule, so long as they haven't caused or contributed to contamination on or after July 1, 2025, we can bring those local governments and all of their properties into the program.
All right, thank you, Michael. I have questions for Michael, but do we want to allow some questions from the audience? Does anybody have any questions? Raise your hand high and they'll bring you a microphone.
There's a microphone coming to you.
Okay.
Hello, Jane Williams with Optum. I have a question about the legal authority to access private properties and private wells. Are you concerned about any data gaps? Because the only jurisdiction you have is to notice and not necessarily sample those wells.
Is this on the,
I'm not sure I could hear the question.
yeah.
Yeah, say it one more time.
Is it not on?
It's on, but it's hard to hear. The
Ask it again.
acoustics
It's a
are
great
bad up
question.
on
Oh,
stage.
sorry. Is there any concern over data gaps because of not being able to access private access wells, like in extremely rural areas like Northwest Florida for PFAS?
For the parcelization part of this?
Well, for delineating contamination, like, because you say
general.
that a private property can't be a responsible party because they didn't generate the PFAS, so you don't have authority to access the private well. So how do you, I mean, are there large data gaps in areas of rural Florida?
Laurel, I think that's a you question.
You know, my guess is that when we start looking for PFAS and other emerging, we're going to find it everywhere. You know, because of application of biosolids and materials that were disposed of in landfills. And that is why I think it's so important to keep the rule structure, that component of the current rule structure in place, which is, I don't have to complete delineation in the 780 sense.
Right.
Because the point is, if I know it's here and here, because I have 2 wells that are meet our data quality standards, that should be, I should be able to just do that and put a buffer around it. And if I'm the party who's responsible for trying to delineate a source which may exist here, that's another issue. In a lot of these cases, you're not going to find a source. I mean, you know, when we're down at the fringes of concentrations, same thing with 1,4-D or other, these low-level contaminants, you don't know where it came
Well,
from.
remember what the rule does. The rule doesn't prohibit potable wells or withdrawals. It creates an extra inquiry step for someone who would want to put in a potable well and hopefully some other types of incursions into groundwater to make sure that they're not pulling up or exacerbating movement of a contaminant plume. So the absence of data here shouldn't matter. It just means that the person who's interacting with groundwater here has got one more additional inquiry step to, and it may just be, where do I case my well to?
And it may be something we need assistance from FDOH on getting access to the wells, or requiring, if you're going to continue to use your well, then you need to sample it. So,
I just wanted to throw one more thing out on what Michael Goldstein was talking about, and I mean, this is a sea change to be able to just designate a small area as a brownfield site and have your regulatory responsibility sort of tied to that. He mentioned golf courses, ag areas, but one area that I think many of us may have, even in a smaller sense, any kind of industrial site or any site where maybe there's been a road widening and a taking, and so now contaminated soil that was part of the site is now no longer owned by, you know, the current owner of that property, or a railroad spur that was adjoining. Those are the big impediments to closure. Often are, you know, the municipality, the DOT, the CSX, where, you know, I bought this. I didn't buy these other areas. Well, at one point in time, maybe they were part of the site. That is huge, and I think we're going to see that tool used, and keep that in mind if you have a site, you know, a corner gas station that's a brownfield site. All of those things, you're no longer going to have that responsibility for that off-site soil impact.
or if
And
you've
that
got
goes
the,
to the definition of what's a facility.
right.
Is that right-of-way that FDOT or the municipality took really part of the facility for purposes of you getting closure on?
It's not now. I mean,
Right.
based
Right.
on this, you can seek closure under these alternative criteria,
Or if it's a CSX rail spur.
or a
right.
CSX
Or
rail
rail
spur,
line.
or a DOT right-of-way.
Yeah.
If the operation was historically on those other areas, and the soil was impacted over there, I own this, I'm not responsible for it.
Well, from a regulatory perspective, right? But now putting on our lawyer hats, our cost recovery lawyer hats, the question is, would that party who gets to take the early off-ramp once they get an SRCO from FDEP, are they still exposed to third-party liability from the owners of we'll call them the tail parcels?
I would say for the soil issues, no, because if I bought this piece of property 3 years ago, I didn't contaminate that soil offsite. I mean, that never was my responsibility. Under the Brownfield program as it was, previously implemented, when you signed the BISRA, you accepted, you said, okay, I'll deal with that stuff.
Right.
But from a liability standpoint, you never had that liability, from my perspective.
Unless you could prove there was an actual discharge that spread on the adjacent property. I think that's a hard situation to actually prove.
Yes, I agree.
Yeah.
Well, the other thing is now we're really getting into inside legal baseball. There is the liability protection against claims for cost recovery
Right,
that you get along with the BISRA,
but not personal injury.
but not personal injury. But in terms of being liable to the owner of the residual piece for cleanup of that soil or groundwater, it seems like you have double protection. You get protection from DEP once you have your SRCO, and then the party who's left out in the cold with the tail piece of the larger contaminated site that wants to sue to recover on a cost recovery basis, they're prohibited from doing so under 376.82.
Well, remember the showing you're still required to make to be eligible for your early off-ramp. You still need to make a showing that you meet closure criteria, including with respect to the tail piece or the remaining contaminated non-brownfield piece, that you are not the generator causing that contamination, or if you are, that you have addressed that contamination. Laurel yesterday, when we were discussing it in the early session, had an elegant solution of putting an NRIC on that, on that tail piece,
Correct, for
on
groundwater.
the groundwater. But you've created, as part of the closure process, a data set that's sitting in the record that's going to make liability pullbacks to you very difficult.
Right, but because under the statute, you still have to adequately address contamination emanating from the brownfield site. Adequately address under 62780, I think we're still seeing how that's going to play out in terms
That's
of
gonna be
what
interpreted.
adequately addressed means, but
That was part of the conversation last time.
exactly.
And
so,
what emanating from, right, you
emanating
got to hit the
from.
emanating from and then adequately adjust.
Right.
Let's
Exactly.
give
They can't
another
be
opportunity
joint
for,
generators.
Exactly.
any more questions from the audience?
Microphone's coming.
You got to say which Michael.
There are 3 Michaels.
Right. Okay, this one's for Michael Goldstein. It's Paco from Landmark Solutions. You mentioned the lowlights of that VICTIC rule. So a little bird has told me that maybe a motive for that rule was when a redevelopment got ahead of assessment. So the building slab is already way over and they don't want to go do assessment or clean up within. So just very conservatively throw some wells on the outside perimeter. You've achieved clean, define everything in there as contaminated. But now that building slab is the costly engineering control where maybe the contamination was only, to use the analogy again, a slice of the pizza, not the whole pizza. So is that the problem that you were highlighting with the rule? And if not, give me a specific example. I'm really curious what, like that's the situation I think of when you mentioned the problems with that rule impeding or disincentivizing a development through brownfield. But is there another example? I'd love to know.
Paco, that's a great question. I'll give you a concrete, the answer is yes. There's a different example, although I can make the argument that over-slabbing a site, provided that it's an approved engineering control, should be fully eligible for the tax credit. It's an aggressive argument, but the argument is this, that if it's good enough for the regulator to constitute an engineering control in whatever form is approved, and that approval is what's necessary to take the risk out of redevelopment and to incentivize the private or public sector investment, then it should be rewarded fully by the tax credit because that's the quid pro quo set up by the legislature. And even if there is a technical argument to make that doing so is a little imprecise, that's a policy decision that I would argue has already been asked and answered by the legislature. But that's not your question. So with respect to the what I think is the most glaring problem with the proposed rule that has long-term implications and ramifications for everyone in this room involved in the program is this. DEP is now looking at old aerial photos of a site. We have a site in particular where we put in an application for an engineering control, and DEP said, we're looking at this aerial from 1970. There was a building on this site from 1970, a finished building, had a roof, and presumably, I say presumably because the aerial only showed the roof, but presumably it had a slab. But we've all dealt with pole barns that don't necessarily have slabs. So be that as it may, DEP said there was a building with a slab here, therefore this 1970 building constituted an engineering control. Therefore, your tax credit for the engineering control is being denied. Now, we subsequently negotiated a clawback of some of that, but from my perspective, a reference to an old building that predated 62780, that didn't have any engineering certification,
That may not even be on the site anymore.
that may not have been on the site for more than 2 or 3 months after the photograph, that's not appropriate. That's counterintuitive and a disincentive to redevelopment, because it creates not just risk in the most obvious sense, but risk in very nuanced ways, because not everyone has access to the same photographs. We're not all on the same page.
So that's part of the practice risk you were referring to also?
Yes.
Like an engineer signing off on that, which we wouldn't do.
Signing off on the application, signing off on the tax credit application, that the engineering control being submitted for a tax credit is appropriate, and then the client finds out 8 or 9 months later that the application is being denied or reduced, and then the client says to the consultant, well, why didn't you know about this? How come we weren't advised? We already factored this tax credit into our pro forma, and now it's a problem.
Well, and Robyn, I've got one question for the panel, and it's
No, go ahead.
a VIC-TIC question. And I think Michael hit it right on the head. Brownfields is not an environmental remediation program, at least it's how it's done in Florida. It's an economic development program masquerading as an environmental remediation program. Because we could do all the remediation we do under Brownfields without the Brownfields, at least in Florida. Should the VIC-TIC review go through DEO as opposed to DEP? Department of Economic Opportunity. Should that be the group reviewing the VIC-TIC applications?
I think that's hard. Do they know enough about it? Yeah. Go ahead, Michael Goldstein.
I don't have a good answer for that. That's something that could be taken up in the Contaminated Media Forum.
Forum, there you go. The Howard Nelson Contaminated Media Forum, yeah.
That's right, but I know we just have a few minutes left. Maybe Gene will let us go over. There was a question raised in the audience by the consultant from Aptum, which I thought was a great question and one that we should tackle in conferences going forward, and that relates to protectiveness of non-recorded institutional controls when either we know that there are parties within the proposed NRIC area who are already on potable water, or we can't know whether there are such parties. And so the question about addressing risk through the mechanisms that exist at the local government level and in coordination with DOH and the Water Management District, they may not reach those parties, right? So as practitioners who are charged first and foremost with protecting human health and the environment, how do we square that circle? How do we get comfortable with advising our clients and just feeling good about going to bed at night, putting an NRIC in place that addresses the business need to help our clients, but doesn't necessarily get us to where we need to be to achieve the protection that the NRIC was designed to provide?
And I think it levers a little bit on the underlying cause for the plume that the NRIC is overlaying. If you are the generator and you have contaminated that area and you're overlaying a well prohibition via NRIC, there should be some discussion as to your obligation as the generator to potentially recase wells so that they're below the contaminant plume. Different from you have discovered a regional, sub-regional groundwater issue that should prevent access to groundwater unrelated to your site. We did one recently in Cape Coral over a golf course area, but the NRIC wasn't related to contaminant load coming from the golf course. It was related to a regional salinity plume, which should have prevented you from casing wells. What obligation do you have outside of notice? You've got wells here that are in a hazardous area if you're not the generator of that.
Well, thank you, Howard, and thank you, Michael Stag, Michael Goldstein, Michael Larson, Howard Nelson, and Laurel. I think it's a good start to the day. Thank you, audience, for listening to a bunch of attorneys ask themselves their own questions, and we hope we give you some tools.